Welcome to the Property Couch, where each week you get to listen to two of Australia's leading property experts. Bryce Holdaway, co-host of Location Australia on Foxtel's Lifestyle Channel, and Ben Kingsley, chair of Property Investors Council of Australia and the 2014 and 2015 Property Investment Advisors of the Year.
All right, folks, you're on the Property Couch, where each week Ben and I bring you the insider's guide to property finance and money management. Welcome to the couch, Ben.
Thank you, Bryce. Lovely to be here.
Hey, Ben, we when we set up the couch, we said that we wanted to leave, we didn't, I've said this a couple of times, we've got 3 seats instead of 2, just for you and me. We leave 1 vacant for some really great guests. And today,
subject matter experts.
Today we've got a very big subject matter expert on, Ben. His name is Tim Gray, and I'll introduce him shortly. But we did a pre-record with him earlier this morning, and it was an introduction to us from Nicole Fade.
Yes.
And he's a heavy hitter.
He is.
He's got a lot of experience. And the fact that, we were able to meet with him and get some of his time was a real joy and privilege. But the fact that we were able to record it for the benefit of our listeners is a real coup for our community.
If I can add to that, Bryce, I think what I like most about some of the stuff, I mean, we do some, lift the eyes, 30,000 feet sort of look down. But today, we're getting into some technical stuff. So the language is a bit legal, but that to me is like, well, that's how...
Subject matter expertise.
And you need to understand this stuff, and you need to comprehend what it means. I mean, you're going into the business of owning a property. You're putting hundreds of thousands of dollars on the table. So having a bit of technical dive, and that's what I love about us. We try to get down into the substance. And we've certainly been able to do that with Tim. Yeah,
so that's terrific. So stay tuned, folks. Hang out for that one. It's a good episode. It might go a little bit longer this episode, Ben, but it's well worth hanging in there.
It is.
And we normally give advice, Ben. You prompt this one, 2-speed.
I say it halfway through because we've had to pre-record Tim. He's a very busy man, so we've gone out and got that recording. Just probably when he starts, slow it down to 1. Yeah. Because you might have to go back, use your 15 seconds back to listen to that bit again.
Let it land, because it is good stuff.
It's good stuff.
All right, before we introduce Tim, Ben, my Mindset Minute theme today is I was Steve Biddulph. I don't know if you know Steve Biddulph. He's a child psychologist, specialist in raising boys, raising families, all that sort of stuff. Right? So he's well and truly on my radar. And he put something on his Facebook post the other day. And I thought it was really great. It's from Hamish Blake. You know the comedian?
Yeah, I know. Yeah,
Hamish Blake.
Yeah. Hamish and Andy.
And it harks back to a conversation you and I were having yesterday.
Yep.
There will be a time when you are, say 85 years old, and you would give anything you had, you'd pay $10 million to be 30 or 35 again, with your little child playing. To be you now, just a single hour. Knowing that now, that one day you would give anything to be back where you are right now. That changes how you feel about your life a great deal. And the reason that resonated with me, because it's really good, because I've got 2 young boys, you've got 2 young boys. And we were talking yesterday, we're children of the 70s. We grew up in a traditional environment where we saw our dads go off to work and all that. And so you and I talk about how we battle that normal for us,
yes,
so that we're present with our children. And so that's something that you and I work on exclusively, but we talked about it being a common thing yesterday because we're workaholics.
Yep.
But that, for me, sort of grounded me. I was like, we
have a bit of a boys' banter, and sometimes we can go a bit too far. 2 blokes having a yarn.
Well, we don't see life that complex. We're 2 blokes who just having a yarn, and at times our worldview is shaped by our own experience of growing up in the 70s. But we're certainly inclusive of everyone. But that one there, to me, was a good reminder for all the parents out there that where you are right now, at some point in the future, you're going to wish you were back at this point. So helps you get a little bit of perspective.
I need a bit of that perspective every now and then.
Yeah, well, you and me both, mate. So you and me both. All right, well, as we said, Ben, at the top, we have got a ripping interview with Tim Graham. So let's cut to that now. All right, Ben, we'll go straight to our very special guest today.
Always very special, aren't they?
They are always very special. Today we've got Tim Graham, who's partner at HWL Ebsworth Lawyers. He practices exclusively in the areas of Strata and Subdivision law, Ironist Core and dispute resolution with almost 20 years of experience, Ben. He's one of Australia's preeminent Strata lawyers. He's the president of the Australian College of Community Association Lawyers and a fellow of the college. Tim has been named in the Best Lawyers Australia for real property law and has been recognised in Doyle's Guide as a leading property and real estate lawyer. He's a council member of Strata Communities Australia. He's also got extensive experience in domestic and commercial construction law matters, providing contractual advice and appearing in building defects claims, insurance reviews, repair and maintenance, and Water Act cases in the VCAT and the courts. He regularly writes for the Australian Property Law Bulletin, of which he is a member of the editorial committee, and periodic publications of industry associations, strata management companies. And he's a prolific presenter. He is well and truly...
He's across his subject matter.
There's a fair bit going on. Welcome to the couch, Tim.
Thanks for the invitation. It's always a little bit, I guess to be called special is capable of various interpretations.
So
we're very special. We always like very special guests on our couch.
It's received the way it was intended.
Hey, your experience is in Ironist Core, it's in strata plans and plans of subdivision, defects, asset and financial management, debt recovery. You've got a bit going on, but how did you sort of take us back to the specialisation in strata and Ironist Core?
After a very short time as a general litigator, I started working in building and construction, mainly back-end disputes, and it just metamorphosed from disputes involving some strata buildings into meeting networks and receiving instructions in matters other than building disputes. So 20 years ago, here we are.
Organically grown into Precisely. What it is today.
Hey,
you go, Bros. No, go.
I guess for a lot of our listeners, they can either buy a house, they can buy a townhouse, they can buy an old school flat. But the latter two, the townhouse and the apartments, typically have a strata or an owner's corp. So let's go to 101. What essentially is a strata, and how does it form, and how do you do the strata subdivision?
It's funny that the way that the demography's changed. I think you look at European settlement around Australia, and what tended to happen was concentric expansion from city centres out into the suburbs, and settlers were keen on detached housing on quarter-acre blocks and what have you. But in the last 20 years, or perhaps longer, there seems to have been this inverse shift back into the city and the amenity and the facilities that it provides. But strata basically, in fact, it's a little bit of a coarse term, strata, that we haven't formally had any new strata in Victoria since 1989. We're really talking about subdivisions, but the nomenclature of strata seems to be understood by everyone. But basically what it means is if you take a plot of land and split it up into parcels, well, that is a subdivision, and also known as strata. So that's basically the way it works. When a plan splitting up land is registered, then the owners corporation, formerly called the quarter body corporate, automatically comes into operation. It's a separate legal entity, and it assumes rights and obligations, functions and duties under the legislation. But it is important to note that it applies both to vertical airspace in towers as well as lateral development. That a lot of the estates out west and the southeast and what have you are based on plans.
Yep. What is most of your experience, going up or going out?
Both.
Yeah. What do you see more of lately?
Well, I think consistent with the comment that there's this push back into the city for urban and living, there's certainly, you need only look at the distending city skyline, the amount of cranes in the air to say that there's still a lot of buildings going up. But I think it's equally appropriate to perceive that lateral developments in Melbourne's a fairly blank canvas. It's quite flat, and we're not encumbered by waterways and topography of, for example, Sydney. Really both, but with a concentration, I think, in the urban and inner urban area.
Mm-hmm. So it's an interesting thing because also it's different in every state and territory. That must make, do you specialise in Victorian-based legislation, or do you moonlight into other legislations?
It's a little bit more than moonlighting. It's fair to say that the practice has traditionally been a Victorian-centric one, but it is expanding, and there are parochial idiosyncrasies across the states, it's true, but it's equally fair to say, I think, that the principles underpinning are identical, not only across Australia, but to a significant extent around the world.
Wow, that's good to know. So, but we've changed the name to owners corporations, but you're still in some states and territories, some are still body corporates? Yeah,
Queensland are still body corporates. Elsewhere, you've got strata corporations.
Different.
It's really a matter of nomenclature. Fundamentally, the entities are similar.
Pretty similar.
Yeah.
Cool. Fantastic. So I know that our listeners who have had experience with owners corporations, the ones that own those investment properties that are part of those body corporates, I want to jump straight into what are the most common disputes that you see as being challenging inside an owners corporation, and I'm sure you've got some great stories.
Yeah, there's some, isn't there? You draw a dichotomy, I think, between issues that arise for off-the-plan purchases as against purchases for the built form.
Yep.
Obviously, there are certain incentives, stamp duty being one, that inform buying off the plan, but that comes with an element of uncertainty and quite appropriately flexibility on the part of the developer. And so there are certain stories that what is ultimately delivered doesn't look exactly like the glossy promotional brochures that that were propagated by developers. But I think there's also a degree of paranoia about that. Most developers are very responsible, and the reality is that when they're entering into contracts and procuring pre-sales, there's only so much known. They're only as good as what they can reasonably know at the time, and that's subject to change with the inflection of time. So there's that. But so certainly in terms of sizes and outlooks and those sorts of things, rules absolutely, whether you're buying off the plan or in built form, that you're subject to properly made rules is something that is really important, I think, as a matter of diligence. In terms of disputes, well, the triumvirate traditionally has been pets, smoking and noise, and I think that's...
Pets, smoking and noise.
Pets, smoking and noise continue to be issues, but the big ticket item in terms of disputes, I think more recently has been service department and Airbnb, and with some exception, it's fair to say that the interests and expectations of a one-night guest are going to be different than a long-term owner-occupier.
Yeah. And what have you seen in that regard? Because that's obviously a huge growth area. So you've got seven people in an 8-unit development that are all living, long-term, peacefully, and then you just get the holiday person coming in. What are the rights of the other 7? Are there any? Is there certain things that someone who wants to put Airbnb, for example, in that they have to be mindful of, or is it grey?
It's grey and getting greyer. We did get a statement out of the Supreme Court a couple of years ago in a case called Belcom, in which the Supreme Court said that it's beyond an owners corporation's power to pass a rule that in that case purported to prohibit letting for under a threshold period of 30 days. But that rule came into operation prior to the Owners Corporations Act, which is almost 10 and a half years old now, and the rulemaking powers are greater under the Owners Corps Act. So there is still some momentum to the argument that a rule can be made to prohibit short-term letting, and that's buttressed by a decision that was published, I think, in the first week of this year, coming out of the Caribbean, which is in the Antipodes, of course. But the reality is that the case was called O'Connor, and the laws involved were based on New South Wales conveyancing strata titles legislation from 1961. So it is germane to the extent that their laws are based on Australian laws. And in that case, the Privy Council, they still got the right to go to the Privy Council, decided that it's quite appropriate to have laws that prohibit that sort of tourist short stay accommodation, given its incongruity, I suppose, with the expectations of long-term tenants and certainly owner-occupiers. So there's still work to do in the area.
Mm-hmm. Mm-hmm. It's fascinating, isn't it? I mean, because this is, technology's leading change. Everyone can buy properties and basically make them hotel rooms under this tech. But I want to go back in terms of the tech place and some of the stuff that we see in our business. We don't do a lot of off plans or brand new stuff. We do a lot more in the sort of established stuff. So some of the stuff that we've seen hit our desk over the journey has been disputes around special levies and who's going to pay for what and can we enforce a majority rule on the rest of the owners to partake in the expenditure that's being recommended. Can you share a little bit of light on that for us, Tim, in terms of the challenges around that and sort of some of the resolutions that you can see, if people are in that situation where they don't have a unified body corporate, what are some of the better ways in which we can solve their problems?
Yeah, there's a couple of excellent points arising out of that. I think the first to note is that when you buy in, you are buying into a democracy. The tagline of the Australian College of Strata Lawyers that was mentioned in the opening is for the common good, and I think philosophically it's important to be aware that you are buying into a democracy. Sometimes Strata is referred to as the fourth form of government, so you are subject to decisions of committees and of general meetings that are properly made. So there's that. In terms of fees, obviously the diligence before purchase is to have a close scrutiny, almost a forensic audit of fees, both historical and prospective. The level of disclosure required in Section 151 certificates takes you only so far. Among other things, what that needs to disclose are existing fees and liabilities, contingent fees, and also the minutes of the last AGM. So it's only a very narrow snapshot of what the financial situation of that building is. So diligence dictates, I think, that Strata inspections are done to look back beyond the minutes of the prior AGM and really get a good feel for it. That process is quite advanced in other states, but it's embryonic if existent at all in Victoria. So there's certainly a lesson there. In terms of contribution to fees, that it's a huge area of dispute. And respectfully, we haven't really been assisted by legislature or the tribunal. The primary position is and has always been that you pay fees in accordance with your lot liability, and your lot liability should be calculated on the basis that a user pays system by which you replenish the resources of the owner's corp to the extent to which you've had recourse to them. And that's probably done quite well generally. But what we've had is this thing that's become coarsely known as the benefit principle, that says that for certain things, the lot that benefits more pays more. Now, in fact, I'll expand on that with your indulgence. What it actually says is that for repairs, maintenance or other works that wholly or substantially benefit some or one but not all of the lots, then the lot that benefits more pays more. So there's a couple of boxes to tick for this rule to be applied. Firstly, it's got to do with repair, maintenance or other works, not expenditure of any other kind. There's got to be this whole or substantial benefit, so it's not a mere differential 51.49 or 60.40. It's got to be whole or substantial, and I think that means that for it to apply, the benefit to some lots has got to be 100% or close to it, and the corollary is that there's got to be nil or negligible benefit to those other lots. So there's that, and then of course the notion of benefit, if you approach that widely, oftentimes it's, well, I'm not getting wet and the leak in the roof's on the far-flung side of the building, so why should I pay?
I was going to say, give me an example, and that's the classic water damage.
It is, and the best case example is a thing called Boothie, which concerned the Grand Central Hotel down on Spencer Street, and it's got the two copper domes, if you're familiar with those, and they were required a couple of years ago to be repaired and maintained to the tune of a couple of $100,000 each, and the Owners Corporation, in its wisdom, passed a resolution that only those two lot owners immediately below the domes benefited from those domes not leaking. Now, that was an untenable situation that didn't last long at all on a challenge, but that's the way it operates. So it's trite to say it's standard that owners come in and they want to avoid expenditure, so, well, we don't benefit, we don't play golf, so we don't want to pay for the maintenance of the golf course or the pool or the gym or whatever. But the primary position is, and certainly for recurrent annual fees, that's the other thing to note, that the benefit principle only applies to special or extraordinary fees. It doesn't apply to recurrent programmed annual fees. So it is really quite a narrow exception to the primary position that fees are paid in accordance with lot liability. So, among other things, purchasers really need to be aware of what their lot liability is, have a look at the financials and do the arithmetic.
Well, I was going to say a segue to that in terms of lot liability, because it'll be useful to mention to the listeners how you come about that, and how do you come about an uneven distribution of lot entitlement for each unit, and is there a science that we can sort of do that? Clearly you're very advanced in your thinking on these things. Maybe
we've been around the road a bit.
Yeah, well, not only that, but I also acted in a seminal decision called the Concept Developer, where all that was tested. So the reality is that when entitlements and liabilities are first set, there really is no test, and they're often done by surveyors, I think responsibly, but also unilaterally and perhaps capriciously, and possibly also they're acting under the direction of the developer. So you can get any old thing, and there's really no test on that. In Section 33 of the Subdivision Act, we've got the preface that in making any change to entitlements and liabilities, and then that sets out what you have to have regard to. So it doesn't appear to apply inaugurally, it applies in making some change. Now, entitlements and liabilities are two different things. We're accustomed to picking up a plan of subdivision. You've got two columns, and oftentimes they've got the same number in them. That won't necessarily be right, because if you think it through, they're really quite different. Entitlement is voting power, and liability is replenishment of the resources of the owners' corporation. So one really doesn't have much to do with the other. Other states don't distinguish. Victoria does under Section 33. If we're making a change, then for entitlement, it's based on value, and for liability, it's based on what is a just and equitable contribution to the general and administrative expenses of the owners' corp. And I think it's something that we do very well in this state, because I think they are very different things. So Section 33 makes that clear. If we're making a change to entitlement, it's based on value, and that makes sense because, for example, in the event of a total insurance loss, insurer's going to pay out, then the money would be distributed according to lot entitlement, which should have some resemblance to value.
Yep.
Whereas the contribution to owners' corporation expenses have nothing to do with value. You just should put back in what you take out. So I think it's something that we do well here, save and except with the qualification that that test doesn't apply when the plan is inaugurally registered. It applies subsequently. So, and just to finish, to round that out, the case of concept developer went to VCAT. VCAT ordered that the schedule of entitlements and liabilities was altered. That was appealed to the Supreme Court, and the appeal was dismissed. So there is ability to go and get these things changed. If they're anomalous or out of whack, then you can make application to the tribunal supported by appropriate evidence and have some confidence and comfort that orders will be made amending them to reflect what they should.
So I know that there's always nuances in every case, and every case is ultimately different. And you've just told us about cases where if there is a water leak, it's going to be very difficult for you to be able to justify that you're not in for it in terms of the whole body corporate. And you were talking about significant advantage being, almost 100% of that. Can you give us an example of where that may apply, where you have seen that being successful, where there has been an alteration to, or in the initial body corporate that has been developed, that there was an argument that would hold position?
Whole position in terms of the application of the benefit principle, and
yes,
that I avoid paying.
Yeah.
There's not many, as I suggested. I think the exception is a relatively narrow one, but there is one that does spring to mind. It's a case called Jalawiki, and it involved a commercial owners corporation down around, I think it was Dramana. I didn't act in the case, but what had happened in that case was that a portion of the fees was resolved to be paid in accordance with lot liability, and a greater proportion was resolved to be paid in some other way in purported reliance on this benefit principle. And the tribunal, it concerned a veranda out over the public footpath, and the tribunal said that it was an appropriate exercise of the benefit principle because the veranda was not a structural element to the building, that it benefited those lots along that footpath rather than the ones at the back. So that was an application. There is another case called Grundle involving a building in South Melbourne that did concern roof repairs, and it's limited in its authoritative compulsion to the extent that the owners corporation it was striking a special fee for roof repairs, so it needed to consider whether the benefit principle applied. Didn't necessarily have to invoke it, but it needed to consider whether it applied. It failed to do so, so the tribunal said it erred at that point. So it was more procedural. The substantive case may still be decided, but the tribunal on that procedural level invoked the principle.
Doesn't it come down to the fact that at the beginning you said you're buying into a democracy? You've got to see that. It's a bit like saying, hey, look, I've got cancer in my foot, and that's not affecting my arm, but eventually it will. and ultimately, the roof leak 4 or 5 properties away from yours isn't necessarily affecting yours, but eventually it will, because it'll affect the value of that unit, which will affect the value of everyone's unit, which over time, I think the key for an owners corp, I think from your key statement, is you are buying into a democracy. And therefore, that it's not you alone. It is the fact that you are buying to that fourth government system, and you've got to realise that in some cases, with few exceptions by the sounds of it, even if it doesn't directly affect you, you are going to be liable as part of a whole.
Look, that's absolutely right. The principle is that a resolution properly made is going to be binding. The properly made is the qualification. If an owner wishes to argue against a decision, it's not going to be upset by the tribunal unless it can be shown that it was either made unlawfully, that it was not made in good faith, or that's in some other way unfairly prejudicial or discriminatory. By and large, you're bound by the majority decision unless you can show some defect of those natures. That's true. And I think the notion of benefit also does need to be approached widely. You might not be getting wet immediately from a water leak on some other part of the building, but the benefit goes wider than that, as you observed. It goes to the, I suppose, integrity and consequently the value of the building overall, general amenity, but also I think risk management, that if black mould gets in and there's litigation as a result, then the owners' corporation is the defendant, and every owner that comprises part of that owners' corporation is therefore an indirect defendant. One of the early cases, the law changed a bit, but the principle, it's still illustrative. There's a thing called McCarthy. It's a 4-lot subdivision in the inner eastern suburbs. McCarthy's owned the lot at the front with their own gate and garage on one side of the property. On the other side of the property, there was a gate and a driveway by which slots 2, 3 and 4 were accessed. McCarthy said, look, we don't use that driveway, we have no need for it, we shouldn't be paying for it. They were given an indulgence voluntarily by the Owners' Court for some time, but ultimately the matter was litigated, and the tribunal found, correctly in my view, that the McCarthys weren't entitled to some subsidy for the driveway that they didn't use. And one of the rationales for that might be that if the driveway is uneven, creating a tripping hazard because of roots, because it's not maintained, or if the security lighting appurtenant to the garden bed is out and someone trips and falls because it's dark, as a matter of risk management, if the Owners' Corps gets sued as a result of that, well, the McCarthys are going to get sued in the same way as lots 2, 3 and 4. So we've really got to be clear on the fact that the Owners' Corps is an entity of itself, and as subject, has a competent defendant in proceedings.
Now, Ben, I guess the common thing we get for people, I often get someone who their budget might suggest that in their mind, they want to buy a house, but in reality, to get in sort of an investment grade suburb, they need to buy something that has an owner's townhouse, typically, right? And so often they say, there's no way I'll be involved in a body corporate. And I always counsel them to say there's body corporates and there's body corporates, because first of all, it's not some person who's just wielding a stick saying you must obey these rules. The body corporate is actually you, and you have someone representing you if you don't want to get involved in it. But if you're a part of a small body corporate, well, then you have more of a voice, versus if you're part of a large body corporate, you're obviously one of us, very small number, you're part of a process and you can really be disconnected. But what would you say to people who would have a blanket fear around body corporates in terms of easing their mind on the lower end and sort of cautioning them on the sort of the larger end?
Yeah, it's an excellent question, and I hear that oftentimes too. And any party that ever ends up in litigation says never again. But you're 100% right. I don't think there is any cause for alarm or paranoia about it. What there is cause for is proper diligence at the front end, and we spoke about that. Just proper inquiry we know where the boundaries are. We know what expenses we're going to expect, whether or not the cladding complies with or is likely to combust spontaneously. All those sorts of things can really be checked at the point of purchase. In terms of once you're in and the governance and administration, I think you make a very good observation that the Owners' Corp is comprised of the lot owners as tenants in common from time to time and shares proportional to their lot entitlements. So they are a part owner of it. And with that comes rights, obligations as well as duties. But have a voice, get on the committee, make decisions in terms of who you want managing. I couldn't overstate the importance, whatever the size of the Owners' Corporation, of having a professional manager. It's just the level of sophistication, complexity and the need for compliance I think the days of self-management are well and truly gone. So I would certainly recommend a reputable manager from Strata Community Association is appointed, whether it's a 2-lot subdivision or a 2,000-lot subdivision, but that doesn't derogate. That then is a contractor to service your needs, and it doesn't derogate from the primary notion that as a part owner, get in, have a say, and have some control of your destiny.
Because you talked about, sorry, but I know you got a question.
Go. I've got plenty.
We sometimes we might come across a 3-lot Strata Owners Corp, and we talk to we sort of get underneath the bonnet a bit, and they say, oh look, the owners have just got this agreement where they pay a third of the insurance each, and they just one guy at the front covers it. What risks would you say that a buyer is walking into when they don't have a professional body corporate manager in, say, that scenario?
There was an amendment a couple of years ago to the Sale of Land Act that to me is very curious, and it says that if the Owners Corporation isn't discharging its statutory compliance requirements, then that needs to be disclosed in the vendor statement. Now, that's good in terms of disclosure, but what it also is a legislative acknowledgement of non-compliance with other legal obligations. So I think that's sort of a bit curious, but you can commit the crime,
so
and that's okay as long as you disclose it.
As long as you're just sort of saying that, it's a bit like the roof's going to be falling in 2 years' time. They're not going to disclose that, are they?
Yeah. So
caveat emptor, isn't it?
So I think that's certainly an issue. The risks, well, as long as they've, their status quo might have worked quite okay. That is often upset, especially when a new purchaser comes in and wants to upset the apple cart. We see that a lot, but the reality is that the legislation imposes compliance requirements, and if they're not being met, then the Owners Corporation isn't discharging its duty of acting honestly, in good faith, with due care and diligence. Now, analogous to negligence, I suppose, if you're not discharging your statutory duties, you're in breach of that, and you may well be negligent.
Tim, this is great stuff. I was just sort of saying, I'll be listening to this at 1 time speed. We talk about getting through our podcast. You can actually listen at 1.5 times or 2 times and can still get a lot more done, be a lot more productive.
This stuff, you got a little land.
We're going to be like, slow it down to 1 because I need to listen to that again. I need to digest that in terms. But ultimately what you're saying is, early on it's do your due diligence, so do your DD. Make sure, and you flagged earlier with Victoria, a lot of that information isn't readily available, whereas in other states they have quite a backlog of history. In fact, the Strata title property that I bought in Cairns, when I was doing my DD on it, told me a story of someone in the driveway had actually been run over. So I had to work out whether, so I had to do a bit more deep diving into that story before I could come to a conclusion as to what my potential future liability might be on that particular event. So that's did I proceed, did I not proceed based on those types of insights. So now, just for listeners, it wasn't killed, just maybe run over a toe. It's not something to be. So that's my DD's discovered that yes, they'd reversed back onto his foot. It was a visitor in the lot, and the person who was also visiting, so there weren't any. So it was just okay. I need to understand that. So that's the first time I'd sort of come across something like that. But it also goes to show you that that information is available if you can go and do that deep dive.
Yeah, the point was that the statutory requirements for disclosure take you only so far, that to physically go and inspect a greater representation of the financial and asset history of the building, I think is a very good idea.
Yeah, that's good.
Take us back to McCarthy, the case you talked about before, and McCarthy just has a house that doesn't have the other 3 units yet, and they want to turn it into, a 4-lot or the
subdivide, like a battle axe subdivision.
So let's assume one of our listeners is McCarthy right now and they want to do that. What are the mechanics? What's the first step? What do they need to do for that to be something that they want to do to actually put it into fruition?
Yeah, it's a fairly simple process, and there's some symbiosis about which one you do first. But the first steps are to engage a surveyor to prepare the plan of subdivision to subdivide the property, and council will need to certify that. It's obviously going to be subject to planning permit requirements, and then with the built form building permit requirements. So whether you go the surveyor first or council, that's where the symbiosis lies, but they're the first 2 steps. But ultimately what happens is a plan of subdivision is prepared, dicing up the land, council certifies it, the document goes into the titles office for registration, and at the point of registration the Owners Core as a separate legal entity comes into existence. It's as simple as that.
and all things going under the reasonable person test as it should, what sort of time frame, and I know that's probably how long's a piece of string, but what sort of time frame should someone have in their head for how long that takes if no one's objecting, if it goes straight forward?
That's the variable, the objections as a planning issue, which is separate. As far as the actual division issue goes, you might experience some delay with council certification process, but really from the point of engagement of surveyor, preparation of the plan and registration, really there's no reason why that can't be a matter of weeks. In terms of achieving council certification of it, there's going to be some more time, but I wouldn't have thought it's going to be elongated. It's a relatively streamlined process. The hiccups are going to be in the planning process, subject to objections and potential applications to VCAT, etc.
Makes sense.
Now, in that particular case that you were just talking about with McCarthy, the existing home before the Battle Axe subdivision takes shape, that is a standalone freehold title. That would be separate to the strata potentially if we were able to get that planning approval through that local council.
Just to be clear on McCarthy, notwithstanding it had its own gate and driveway, it was one of 4 lots.
That's right.
But you're just using that illustration for if you are the homeowner that you want to subdivide your backyard. You don't have to be a part of the owners corporation.
You'll be separated from that owners corporation. You'll be standalone free title as opposed to a strata title.
Yeah, fundamentally that's right. The surveyor's task will include considering that question. There may be services that dictate towards you being a member of the owners corporation if it's going to be a matter of plumbing, whether it's sewage, stormwater, whatever. Of itself, I'm not convinced that is a necessary reason to be part of the subdivision. That can still be dealt with by way of easements or other mechanics. But you see it, for example, around this area with terrace houses and what have you. Oftentimes they're based on plan of subdivision. There's no common property. The reason that the owners corporation exists is for shared services. Whether it has to or not is another question.
Cool. We often get questions around stratum and obviously company titles.
And community in South Australia.
Community in South Australia. So, do we want to just sort of spend a moment in talking about some of those other titles?
Yeah, well, to an extent, that's a bit of a misnomer because company shares certainly aren't titles. What happened was after the Second World War, with the influx of returned servicemen and the need to quickly house people, that's when the notion in this country of medium and high density living really came into operation, and there wasn't a system of property laws for it, so it was dealt with as a matter of company law. And what would happen is that property would be developed by a company, and shareholding in that company would entitle you to occupation of a certain space, and you'd be subject, and the company would be governed by its constitution, which is its memorandum and articles of association and potentially service agreements and things of this nature. So you were a shareholder, you weren't a property owner at all. That was a company share. In 1960, we got the Stratum Estates Act, which was still based on a company, so it had most of the features of company share, save and except that a certificate of title did issue. And then we got the Strata Titles Act in 67. So from Second World War up to 67, you're talking company share and stratums. And the importance to note is that really a company wasn't a system of property ownership, it was a system of company ownership.
Yeah, because the banks have challenges with lending against company title because they're not buying real property, as you pointed out. They're buying shares, and then that has different volatility and risk attached to it. Yeah,
that's absolutely right, and it's one of the indicia or motivations for converting a company share or stratum into a subdivision, which it's a relatively laboursome and not inexpensive process to do that. And inevitably what you find, well, if it's streamlined it may be, but inevitably what you find is that share certificates are missing or titles are missing in a stratum and all that. So you get all these deviations as you proceed. But the benefits of doing it, I mean, company structure and the corporations law is ill-suited to managing an owner's corporation and the sort of challenges of the kinds that we discussed impose. In terms of value, in terms of lendability, etc., there is certainly a lot of good reasons to convert.
And in the memorandum and the articles, you could have that the owners all have to agree for the new person coming in, or all have to agree when they sell out. So there's some quirks that they can weave into those articles. Is that right or wrong?
Yeah, that is right. And would you believe I found myself about 18 months ago advising a client to convert from a subdivision into a company because they didn't like some of the ilk of purchases to actually take it the other way. I don't know that it's ever been done before, but it's the only way that you can really have any control over who comes in or not is pursuant to a company constitution. So
yeah, I've seen some of those in the articles around pets. So company title properties, and basically the shareholders need to agree to the quality of the person before the property is sold. Now, you can understand that from a lending point of view. It's like, well, that's going to lessen demand. Like ultimately, if they have this, closed user group and they might be part of some sect or something like that, all of a sudden you've got this massive problem in terms of realising the value of that asset for the bank and why they want to lend against it. So it sort of makes sense, doesn't it?
Yeah.
So Ben, I've got some frequently asked questions here. I'm going to fire them at Tim. So we'll see how many we can get through. But someone keeps having loud parties in their unit and they ignore any letters from the Strata manager. What else can they do about that?
It's clearly a rule breach. You've got to, as to whether or not that person is an owner or occupier, may be a different answer. If it's an owner, well, you sue them and they'll be restrained from creating that noise. If it's an occupier, and particularly a short-term occupier, it's often you won't know who they are and they've gone and the noise has stopped by the time that you find them. So there's a question about whether or not you can hold the owner vicariously responsible for the acts or omissions of its tenant or short-term tenant. But on the face of it, it's a rule breach. The tribunal can make orders that noise is ameliorated. The problem with noise, of course, is that it comes and goes.
And it's subjective.
And it's subjective, but the authorities say, well, it becomes less subjective.
Reading, isn't it?
If you get an acoustic engineering test, which probably works with a nightclub, and there's 2 noise cases out of the George Hotel on Fitzroy Street in St Kilda, where they had to install noise limiters to achieve a SEP N2, some decibel level less than SEP N2 required. But that's okay if you've got a nightclub and it's constant. You can get your engineer there. If it's an ad hoc party from time to time, it's very difficult. Yeah. But basically what you can do really is get as good evidence as you can, even if that's diary notes of times and whatever. At the end of the day, the tribunal is going to judge that objectively. So if you've got that evidence, it might fall short of an acoustical engineering test, but the tribunal decides cases on the balance of probability. So if you've got good diary notes and those sorts of things, you can have some reasonable expectation that your case is going to be successful.
Okay. Got to remember you're buying into democracy, Ben. That might happen. I want to use the swimming pool at 11:30 p.m, but the Secretary of the Owners Corp says I can't. Is this enforceable?
First of all, it's not up to the Secretary. It's up to the Owners Corporation to create rules. The Secretary doesn't have any unilateral power over and above that democracy. Look, there's a case called Metro out of the Docklands where the Owners Corporation, it would seem quite responsibly, it was a house rule, but let's assume it was binding. They had this practice by which you couldn't use the gym until you've undergone proper induction. Now, that seems appropriate, but the tribunal said no. As a part owner of the common property, as a tenant in common in shares proportional to that lot entitlement, my ability to use the common property is unfettered, and therefore that inhibition was unsustainable. So the Secretary unilaterally can't. The Owners Corp query whether the Owners Corporation can. According to VCAT and Metro, it can't.
Okay.
Got that one. There we go.
Who's responsible for cleaning the exterior windows of my unit?
Depends where the boundary lies. Again, Victoria's a little bit unique in terms of boundaries. When the plan of subdivision goes in, it specifies whether the boundaries at the interior face, in which case you really only own the airspace between the walls, floors and ceiling. The median, which is the halfway point of the structural, for example, wall, or the exterior. So depending on where your window sits in juxtaposition with where the boundary lies according to your plan of subdivision, the responsibility follows.
Okay. All right. So
did you get that?
I'm going to have to rewind on that one.
So basically, if the window's pitched out in line with the building and the board, then it's more likely to be the body corporate. If it's set in terms of an old traditional window set, am I sort of reading that right?
Let's look at it this way. In terms of a wall, if plan says that the boundary lies at the interior face of the wall, you don't own the wall. you only own the airspace, so anything to do with the wall, including an aperture window within the wall, won't be your responsibility.
So that's the interior boundary
If the plan says it's interior, the plan may say it's the median, in which case you own half the wall, and let's say it's common property on the outside, the Ironist Core owns half the wall. That's a difficult one. Where does the window sit in relation
it's on the outside for sure.
that halfway point? And then the plan may say that the boundary lies at the exterior face, which means the wall and the window are yours and your responsibility.
What's the most common approach to that, whether it's the median or the middle or the average or the centre or the inner wall, the outer wall?
It seems to change with the season a bit. It certainly makes sense for the Owners Corporation to have responsibility for at least the outer half in order that it can have sovereignty over program maintenance and repair. It's an untenable situation, I think, to have an exterior face boundary, and let's say that there's some structural inadequacy with the wall, to have each lot owner fixing a part of the wall. It's just not going to work. The immediate boundaries have their own difficulties, that when you're splitting 50-50 or, it might be some other ratio depending on where the element sits in comparison to where the boundary lies. Rule of thumb's 50-50, but it's really a tape measure job to be specific. So
imagine the poor old owner of floor 71 at the Eureka Tower, who's actually, what you described, it's actually their responsibility. They'd be like, trying to reach out.
Well, they'd be sensible not to hope. You'd think their common sense would be.
Well, you'd think when they set it up that they'd think that through.
You would. Certainly exterior face plans are the least common. As far as you ask me what I see most of, I think it's probably a fairly even split between median and interior face.
Okay. Just on that point, in one of those bigger buildings, I was reading a couple of years ago where a developer had retained controlling interest of the vast majority of the units in the block and wanted to put Foxtel in. And obviously, because it's a democracy and everyone got to vote, they had the controlling vote. So they could control that everyone had to pay to have Foxtel installed because he wanted to have Foxtel on all of his units.
There's probably another way of doing it, but certainly controlling vote is one thing, and at first blush that everyone's going to be bound by that. We made the observation earlier that a majority vote can be upset if it's prejudicial, unlawful, or made in bad faith. So there's all that. But the other thing I think to note in that space is the doctrine of implied easements, and the Subdivision Act will imply an easement if it's necessary to secure a function, and if on balance it's not, I suppose, unbalanced as against the interest of other owners. And oftentimes when you think of easements, you're talking about rights of way and these sorts of things. But the Subdivision Act does make it clear it goes to services of any kind, so that probably includes Foxtel. I would have thought these days you could get a buy as an implied easement.
Yep. Okay. Interesting.
Can I install an air conditioning unit to the outside of my unit?
Probably not. It depends. If there's no other place for, if you accept that air conditioning is necessary, then if there's no other place for it, you would have an implied easement argument. But and there are some cases where that has been found, but the bulk of cases have gone the other way, that you can't just tack stuff on to the exterior of the building willy-nilly. Okay,
so you go to the body corporate, you're in Queensland, it's reasonable to have air conditioning, but the body corporate says no, it just looks ugly, but there's precedent in the building. Do you have any pushback against that or none? Does the precedent give you any weight?
It's not a legal precedent per se, but it certainly would underpin arguments about discrimination and unfair prejudice, etc.
Can I erect a pergola in the rear garden of my townhouse?
If it's so the garden is your private property, we're assuming that, then subject, as long as you're
taking onto the building, which is common property.
Just don't do that. Have a freestanding post, and just touch it off.
Again, it's going to depend on the state. I should mention that my comment about implied easements is limited to Victoria, and that might apply again. We're assuming that the pergola, that the back garden is private property, that the pergola is being built for all intents and purposes entirely within private property, then subject to planning and building approvals, you can do it. It would also be subject to registered rules, although query whether they can stop you doing that. If you need to tap into common property building, you might also say you've got an implied easement of support.
Good point.
Ben, a couple more if you've got
Yeah,
something.
I'm loving these. Keep them coming.
The visitor's car space is usually vacant, so can I park in that space considering I'm a resident owner who doesn't have an allocated car space?
Probably not, for a couple of reasons. Firstly, the model rules in Victoria provide that you can't obstruct the lawful use and enjoyment of common property on the part of others. So by virtue of your car, or of your vehicle's mass, that is an obstruction, so you're in breach of the rules. But the other thing where you might trip up is that visitor spaces are often requirements of planning permits. So you might find yourself, and the Owners Corp might find itself, subject to enforcement proceedings under the Planning Environment Act for breaching a permit condition.
Okay. Heard it here
Don't
first,
park in the visitor's car park if you own. You don't have
Correct.
one. Buy one of the ones with car park on title.
Correct.
couple more, Ben. I'd like to install a storage box in my car space. It's probably sort of a lead on from that question.
Yeah, I think it is. If the planning permit requires a car space to be a car space, then storage is not a car space, and there is a decision that went to that. I think it was called Nova Stargate. But subject to rules, subject to permit conditions.
Okay.
So what I have seen is some of those storage boxes have been mounted to the wall, so the space can still be used, but they're using that airspace that is available on their lot. And I think that's fairly reasonable. Still obviously subject to fastening to common property and getting all those approvals.
Yep.
But that's potentially a way around it.
And last one for me, Ben, is how long do body corporates, owners corps need to keep records for? So you talked at the beginning about your DD when you're buying. How far can we legally go back before they've breached that if they aren't able to produce?
Yeah, it depends on the state legislation. In Victoria, it's fundamentally it's 7 years. I'm going off the top of my head here. I'm pretty sure it's 7. There are certain class of documents that need only be kept for 12 months, which I think, off the top of my head, are proxies and voting papers. Everything else is 7 years. I think I'm right in saying.
Yeah, okay.
Well,
that's not bad. Question without notice.
He's a gun. Tim is a gun. There's no doubt about it. My last one's actually a big one. Are you ready for it? We get people who ring us up and connect with us after buying an off-the-plan apartment.
Oh, yes, this is a good one.
And they are thinking that they've bought into a Legoland, sort of what we call investment stock. And they're now very worried because they've been sold by a spruiker into what they don't think is going to be an asset that performs. Now, they've obviously bought, it's not coming out of the ground yet, so it's pre-sale. And
settlement in 18 months.
Settlement in 18 months with sunset clauses and the like. They are looking for ways to, see whether that contract has been, executed correctly, or if there is a way that they can get out of that purchase. Our advice is simple. Go and speak to a property lawyer and get them to, vigorously look over all the details in that to see whether there is, something that could happen there. But what's your advice when you may get a call like that where someone's come and said, I think I've made a decision at a weekend seminar and they've got me all excited and they've sold this dream to me and now I'm having second thoughts and I'm obviously outside my cooling off period.
Subject to cooling off. Yeah, it's probably not one that can be answered with general ubiquity. It's going to turn, I think your advice is absolutely sound, that it's going to turn on the specific conditions of the contract. Plainly, it's cliched, but the cost of bad advice is obviously greater than the cost of good advice. Mm-hmm. And there's no substitute really for getting good advice on the four corners of that document. The advice will go to things like, material change and whatever. Yeah. But, that's probably the best I can do with that one.
Okay. Mm-hmm. So in other words, if you're in that situation, and we've had a couple recently in our business where we've said you need to get it. Now, would you recommend seeking advice from a legal professional in that jurisdiction? I would have thought so. Like in other words, if it's Queensland as an example, to go and speak to a member of, is there any sort of association you want them to be involved in terms of their subject matter skill?
I better give it a plug, given I'm the president, but the Australian College of Community Association Lawyers, we've got with the times, and we just changed our name to the Australian College of Strata Lawyers, which is, I think we shaved off about 7 syllables in doing that. But, so, look, it's a shameless plug, but the reality is that the college has, he's made of strata law specialists across the country. Yeah. There's no doubt non-members are excellent in this stuff. I'm less likely to know them, but what I can say is that given the exclusivity of the college members, then you're safe. If you go to a member of the Australian College of Strata Lawyers, then they're going to be all across this stuff. There's no doubt.
And so thank you, that's a great plug, Tim, that's great. Material change that we talked about straight away, and we just mentioned there again, is there a percentage that is acceptable? 5% material change, 10% material change? In other words, I've signed up for a two-bedroom apartment, and it turned out to be a one-bedroom apartment. That's a material change. I mean, that's fairly easily argued. But there has been, we had one recently, I'm just trying to remember what the story was. But
I was involved with a developer on the Gold Coast way back in the 90s, mid-90s, and the developers were just not making enough profit. So he just hit the button and everything shrunk by 30%, which is material to the buyer, but ultimately the developer just needed to trim their margins so they could demonstrate to the bank that they had a profit
needed
level
to say
that
you
would get
didn't
the
work
funding.
for that particular developer.
Well, no, but you're just exposed to all these
Yeah,
architects who, and Gold Coast is white shoe brigade, so you hear some of these things.
Yeah, well, I think you've got to have regard to the circumstances of the matter. 2 bedrooms into one's clearly material, 30% is clearly material. Yeah. I think there's some authority, the rule of thumb puts it about 2.5%. It's not great.
That's good.
But,
that's pretty good.
It's going to depend on other things, but that's a rule of thumb.
Yeah, I remember the one where the developer basically set the plans, got the plans, the permits done, and put a common wall in and split out what was meant to be a larger apartment into 2 separate apartments.
Oops.
So obviously because they weren't allowed to do that, and so our client's done the DD and basically said and the council's gone, wait a minute here, 2 years ago this thing's built, now people are using it for dual incomes, and trying to maximise their yield, and they've sold it as that. But ultimately the plans and permits never had that. So it's got that landing room. You go into it, and then the 2 doors go off it. And so they've just built a wall in there. So they're in a bit of strife.
Yeah.
And that body corporate's now going to have to deal with that because ultimately, it's an established entity, and this building has been incorrectly, developed. Oh, there's some crooks out there.
Very good. Well, Ben, I think for the listeners, I think from the quality of the answers that we got from Tim, we realised that we're lucky to be able to bounce this off. He's clearly got a lot of experience, and before we push record, he's a very, very busy man. So we appreciate that you've taken the time to come and share your insights and your knowledge with us, Tim, and I'm sure the listeners will well and truly benefit from that fly on the wall chat.
Oh, and we'd love to have you back on. In fact, I suspect that, maybe twice a year, this would be interesting stuff that people, because these are the sort of challenges that, as you say, you summarised it beautifully by saying the best advice is the early advice. It's far cheaper, it's far more insightful, and it's going to cost you a lot less in terms of stress, not just in terms of hip pocket. So that's what we always, I loved your analogy before, get a great great body corporate management business in.
Yep.
Just like we say about property managers, don't self-manage your property. You're just going to get yourself into an area that you don't understand. You think you're saving money, but at the end of the day, when something goes wrong and you've got to go off to VCAT and you've got to go off to tribunals, you've got to do all this work,
you knows what they're talking about.
You're going to have headaches and headaches and headaches. Is it worth that, 5, 6, 7% that you pay? I don't think so, in terms of what that looks like.
It's been a privilege. We appreciate your time. Thanks for coming on the couch, and we'll get some feedback from the listeners, Ben, and we'll let Tim know, and we'll see if we can squeeze into his diary at some point early next year and get him back on the couch. But,
Bryce, Ben, thank you both kindly. Appreciate it.
Good on you. Thanks.
Cheers.
Tim. All right, Ben, that was a terrific interview. Lots of really important stuff. Now, Tim is well and truly going to say, hey, look, that was general advice.
Yes.
If you've got anything specific, go and specifically talk to someone. But in terms of general advice for us as the listeners, that was pretty good.
Yeah, because what does that mean to you as the listener? Don't just sit there and say, well, Tim said this, and so now it's fact. Obviously, he doesn't know everything about your particular circumstances.
Well, it's fact for the circumstances he was talking about, but not yours. Yeah.
And you could see how he framed the responses and the wording and the language around that. So he was trying to qualify the particular situation. So don't go off and think that that's how I do it myself. Just basically go and get that legal advice.
Yeah, but gosh, if someone didn't get 2 or 3 or 4 or 5 key points there.
Great insight. That shouldn't scare people off from Strata. It's also important to understand Strata's been around for a long time. And most of these are the 1% of times, 2% of times. So, they still make for good investment.
Ben, can I say as a buyer's agent, the thing I want to say about Strata is the nirvana is a house, right?
Yep.
Everyone in a perfect world would like to own a house, but don't make a decision based on where you're going to buy just because you're trying to avoid body corporates. Because I would say there's body corporates and there's body corporates, and we talked about that in the interview. But certainly, we're a highly urbanised country on the fringes, on the coastal fringes, where people want to stay in these main centres. So if you want to be there and you want to be amongst the action, as affordability becomes an issue for the next generation of buyer, they will have to consider buying into the fourth government, Ben. They'll be buying into a democracy. So don't blanket discriminate against all body corporates. Find out the ones that you'd want to embrace and the ones that you'd want to avoid.
Because why do we buy property? Ultimately, two things. Firstly, for us, it's about an investment return, but we're also providing some shelter and accommodation for someone who might be new to the country, someone who's new to the area, or someone who likes to live in that location to give the living and lifestyle. So, but ultimately, we're about a return on investment.
There we go, folks. If you've got any questions that you would like us to answer and save up for the next time we have Tim on, send it to us, info at the Property Couch, and we will well and truly cover that. We enjoyed that, didn't we?
Yeah, we did very much.
My life hack today, Ben, comes from Nick Drever, who sent in. Remember, I put the call out for people. So I'm starting to get some through. So I'm getting excited, Ben, because we're hearing from the trips. There's no point us writing a book and it doesn't include the people.
No, that's right.
And we're getting some good feedback too, Ben, from people saying, I've implemented it and it's done this on the upside. And I've implemented it, and this is where I'm vulnerable. And we're particularly keen to hear where people are finding themselves vulnerable. Because part of the book is we're going to front foot that to see where people can get caught out in the book, so that they can make sure they don't do it.
Some overcoming techniques to get past that.
Yep. So Nick's given life hack today: withdraw your weekly discretionary spending amount in cash. I'm tech savvy, but we live in a world of credit cards, phone banking and PayPass that makes it very easy to overspend. Paying for coffee, beer and takeout in cash makes me a lot more accountable. Ben, it's a nice little tweak.
Yeah, well, I mean, ultimately, we're trying to move you to the new age, Nick, but this is a mindset and discipline thing. So if anyone's listening to this, how do we overcome that? Effectively, think of your debit card as cash. So when you hold that card in your hand, you see that as cash. Okay, and your balance, when you pick up your phone and check your balance, that is cash. And ultimately, no other card lives in your world, no other means of income or available access to money lives in your world. If you can do that, you will overcome the need to have it in cash, because you will know that that debit card is ultimately your only amount of cash you've got for that week.
Ben, what I like about Nick's comment here is I see it as pre-seasons for Money Smarts. Full disclosure, when I first implemented Money Smarts into my own world, I did exactly that.
Yep.
I did it in cash.
Yep.
I did it for enough to reprogram my mind.
Yep.
And then now my wife and I use textbook Money Smarts with a debit card.
Yep.
But in the pre-season where we really needed to change mindset, Ben, that was a very good way to do that.
And so I do the same. The only thing I get my little chicken roll, as you know, most of the time. Treat myself once a week.
Listeners, I've got a photo. I've got a photo that we're going to post, Ivis, aren't we? Of Ben eating a healthy breakfast this morning. I almost fell off my chair.
What do you mean? Cocoa Pops and Fruit Loops aren't healthy?
Mate, so sorry, I just had to put that in because you're about to say, because you have your chicken roll.
Well, no, so I take $50 cash out on a Thursday for my $10 lunches.
Yeah.
Okay, so that's because what I don't like is they ping me. I have to have a minimum spend in some cafes of $10, or they'll ping me 50 cents. So I do take a little bit of cash, but the rest of it is basically all off the debit card.
There we go. So thanks, Nick. Keep them coming, folks. If you want to be in our book, we're going to put the very best ones in the book, Ben. Yep. So that's a very good one right there.
I think Nick's going to get in the book.
Nick might get in the book on that one. So also let us know how it's working for you. The testimonials, we're going to put those in as well. Did you know, Ben?
Did you know? So I thought I'd just do GDP turnover.
Okay.
So it's just something, so gross domestic production in Australia. So this is data from 2009 from our friends at Wikipedia.
Yep.
So they tell us that our economy, in terms of our gross domestic production, is 1.69 trillion per annum. So that's a 2017 number. Obviously, it would have grown a little bit by then.
It's 1,000 billion, Ben.
It's 1,000 billion, Bryce. Think of that, 1,000 billion.
Because a billion's 1,000 million.
Correct.
So we've got 1,000 billion.
1,000 billion.
Wow.
So, and we're also the second wealthiest nation behind Switzerland, with the wealth basically, sort of sitting pretty high per capita, which is pretty good. So second.
Oh, is that because it surprised me until you said per capita?
No, per capita. So that's all pretty good. Now, you probably say, well, who are the biggest? So I'll just give you the top 5.
All
okay,
right.
so
what about
this
last
is from,
week, a couple of weeks ago, when you read out the top 50? We don't get.
Do you want top 50?
No, 5.
So this is from Investopedia, investopedia.com. April 2017 data. I just got it straight off their website, so I've got to acknowledge them.
Yeah.
I mean, if I'm using other people's content, let's acknowledge them. US, 19.42 trillion. China, 11.8 trillion. Japan, sort of falls off a cliff from the US to China. That's a big drop. And then right down to 4.84 trillion. Germany at 3.42 trillion. And who's the last one?
Well, I can see a piece of paper over this. That's not fair. It's not fair.
Ibis.
She's not going to
No,
answer.
she's not going to answer. Okay. United Kingdom. United Kingdom coming in at 2.5 trillion.
Trillion. That's trilliant, mate. That's trilliant.
Trilliant. Brilliant.
It's trilliant.
There you go.
The stuff you've done.
Another did you know insightful commentary.
That top 5 was the GDP of all those other countries, but we're not even in the top 5, but we're the second wealthiest nation per capita.
So we're about 14th globally in terms of top.
Right.
So we come at 1.69, so 2.5 trillion. So Brazil, all these, India, all these other ones.
We have stacked value today, Ben. Absolutely stacked value. So apologies to those people who usually listen to us during their gym workout or their commute into the office. We'll probably have to the commute home as well. As
concentration show.
As well as the next gym workout. But mate, it's been fun. Hopefully people got a lot of value out of that. And again, we thank Tim for his time today. But until next week, Ben.
Knowledge is empowering, Bryce, but only if you act on it.
Hear, hear. See you next week.